You're live.
Oh, I'm glad you have my back. It's always nice to legislate.
I'll be moving
Council.
over there, so sorry.
Okay, ladies and gentlemen, we are going to go live. Are we live? We're live.
You're live.
Welcome everybody back to Senate Economic Development, Housing and General Affairs. It is good to have you all here. We are going to begin. I thought Nate was joining us. Is Nate joining us?
With me. He is, but he has to come, deputy, he's coming, he has a meeting, so he's gonna come to 2 o'clock. Is he Betsy?
No, Nate, he's the Deputy Commissioner of
Deputy
Department of
Alex.
Housing and Community.
Oh, that Nate.
Yeah, Nate Formula. And he, because Alex can't come today. Okay, so we will, I don't think we're gonna begin with John because John's presented the amendments. I think we're going to begin with all the witnesses. And I think, David, you're on deck. I think you're our first witness that we're going to, because Ted can't make it till the end as well. So,
But it's Jessica coming.
no,
Betsy,
yes, Betsy is represented by the board.
just by the board. I mean,
Not
not
just
judged
by
by
the
the board.
There's no judge.
Well, I mean, but, all right, just, yeah.
By the board. The board is here. 2 of the board members are here. David, welcome. If you'd be kind enough to introduce yourself, and we would love to have you discuss why these.
And is Tanya Otter or something?
Yes. David, are you with us?
I am. Can you hear me?
Yes, we can.
I'm
can.
trying to figure out why my video is not. Oh, here we go. Sorry. You know, it's morning and my brain isn't working as well as it does sometimes. Good morning, everyone. For the record, my name is David White. I'm president of White and Burke Real Estate Advisors, consultant to numerous communities, I think you know, regarding tax increment financing, and also have been deeply involved with the CHIP program since it was first simply a raw baby concept and hadn't yet even been adopted. So deeply involved last session, including testifying in front of your committee on a number of occasions. And what brings me to you today is that there's been considerable discussion in recent months over the implementation of the CHIP program, Community Housing Infrastructure Program, and whether there perhaps should be some amendments to the statute as originally adopted in order to smooth some rough edges out. And so that's what I'm here to speak to today. Let me start by saying that I just want to.
May I just ask, what are the rough edges that you are wanting to smooth out?
I'm going to go into detail about that, Senator. But I do want to start by just simply giving kudos to the VEPC board and staff, because they worked unbelievably hard to get the guidelines in place in time to actually launch this in January. And they did a phenomenal job, and they really deserve huge credit for that. The second thing I want to say is that there's been concern that there haven't been any applications yet, and is there a problem here? And I'm not worried about that right now. It's a new program, because the guidelines weren't available until January, and the program didn't launch until then. It's just taking a while for communities and the development community to absorb it and to figure out how do we actually use this tool. So I think we're on a good trajectory with regard to CHIP, and I'm not concerned about. Some have been concerned. It seems to be a slow pace of adoption. I don't think that's the case here. I think it's appropriate for a program that's new as everybody tries to figure it out. Nonetheless, there are some issues. And so to your question, Senator Clarkson, let me speak to some of the things that we're concerned about. Now, there is a draft of potential legislation I sent to your staff person, and perhaps copies have been provided to you. This is CHIP proposal draft 1.1 dated 4/30/26. John Gray from Legislative Council drafted this. Do you have copies of that?
It's getting printed right now.
Okay. Well, let me just launch in. So one of the key things that has been of concern.
David, we have reviewed those. So we we have reviewed them, we walked through. So feel free to just address them because we have walked through them.
Okay, I'm sorry, I didn't understand that. Thank you. That's helpful, Senator. So one of the key concerns that has been raised in the past, that is being raised now during, as people have been trying to do this, is ambiguity around what infrastructure can be privately owned versus publicly owned. And that discussion took place last session when it was adopted. And the general sentiment, as I understood it at the time, was that most types of infrastructure could be either publicly or privately owned. And there was a point when the decision was made to change the language that is used in TIF, which says that the infrastructure needs to serve a public purpose. The language for CHIP was changed to serve a public good. And my understanding at the time was that from the explanation from John Gray, and again, this is my understanding, was that change meant that things could be privately owned. That public purpose meant public owned, and private and public good meant it could be privately owned. But that's because it doesn't explicitly say that, there's been some ambiguity. And so the question is, what is the public good and how is it defined? And so it's making it very difficult for communities and developers and VEPSI staff, for that matter, when looking at a potential project, to understand up front whether a certain type of infrastructure that would be privately owned, perhaps the parking, for example, for a multi-unit building, would be eligible. And so the first change here would simply try to clarify that the public good is the housing itself. And that is the infrastructure, whether publicly or privately owned, is serving that purpose of the housing that's being created, that in and of itself meets the definition of public good. And
this is David, this is under the improvements section, and correct. You're eliminating, your proposal is to eliminate options and just have one or the other. I believe you've removed the and you are wanting to have a choice of only one or the other.
Well, actually, the language as proposed here says that it will serve a public good by fulfilling the purpose stated in the section, and the purpose is the housing. And then it makes it clear that is the public good that needs to be served. It's not the infrastructure itself that needs to serve the public good. It's that the housing is the public good. And as long as the infrastructure is serving that housing, then it meets the definition of public good, if you follow that distinction.
Yeah, we'll have Ledge Council go through it.
And it would help me a lot if we paused on each of these to hear from the VEPSI board or VEPSI. I mean, this is why I didn't want to ask you to speak to the exact guidance. I figured we'd have that up because the question then is, did you all feel like you had to interpret the intent to write the guidance for the section?
I would prefer to have, because we have people who are only able to get, I would prefer we could go through all the amendments and then
have the guidance printed out.
I think we have the guidance on the website, so John can pull up the guidance. But would people rather do it amendment by amendment? I mean, we don't have all the witnesses here who are going to be testifying, so I'm happy to do
Are you
it.
speaking of like Wendy and Abby to speak to us from Pepsi?
Happy
Wendy from writing?
Wendy just
No, I'm
happy to go through each one of these if you want, but I think I was sort of hoping that we would just get through the proposals and then we would discuss them.
Okay, so, I mean, I just want to say, like, I had been talking to Jessica since right after the conference committee and the dust settled about, like, particularly the inability to oversee the second home piece. So I'm just saying, I know that there was, I don't know what the discussion looked like about each of these, and I don't want to lose track of that as we go through each one.
So this is pretty much the same as what we already have.
Like, does VEP do?
I think
the
you're gonna
VEP board
hear from
agree?
the Pepsi board members
Yeah.
about the whole discussion and, after David's done. So David, if you just finish and then we can go through and look at guidelines and hear from Pepsi, hear from, our auditor and hear, from our JFO.
Did we invite tax?
No, I invited the people you see in front of you. Invited, the Pepsi board members, we invited, auditor, and we invited JFO.
I mean, taxes who have boosters is for.
Fine, we aren't hearing from them today. We can hear from them later. David, would you be kind enough to finish?
Okay, great. So the second suggested change that you'll see on subsection 18 is related costs. And right now, as it's written, related costs, and just to be clear for those who are not familiar with the concept, that related costs are those costs that are involved in either setting up the chip project itself. That is, going through the process of determining the feasibility of it, going through the process of negotiating the housing infrastructure agreement between the municipality and the developer, going through the process of applying to VEPSI. It's all the process of setting up the chip. And then administering the chip in the future, the operational costs. It has nothing to do with the cost of the housing development itself, nor of the infrastructure itself. But these are the costs like attorney's fees, consultant fees, application fees that are involved with establishing and operating the chip. So these are the so-called related costs. The direct costs of designing and building the infrastructure or the housing are not related costs. Those are direct costs involved. And so under the current way it's written, it only allows the municipality to be reimbursed for the related costs involved in things like setting up the chip. What we're finding is that in many communities, it's actually the developer who's taking the lead because the community either doesn't have the staff capacity or perhaps they don't have the funding available to be able to front the costs to be able to do that. So that the developer is actually carrying that financial cost up front. And ultimately, it is my recommendation that you allow those costs, whether incurred by the municipality or by the developer or the sponsor, and the sponsor would be the entity that's financing it, that those costs are also eligible to be reimbursed, not solely if it's paid directly by the municipality. So that's the second one.
You say eligible for being reimbursed. Who is the one that will determine that eligibility in your mind, David?
So it's really no different than what happens today, let's say with a TIF project, which is that the municipality will, in a TIF project, will pay those costs, the attorney fees, consultant fees, and so forth, and ultimately can get reimbursed either out of the bond that gets issued or directly from increment. And so this would be, in this case, spelled out in the infrastructure agreement, housing infrastructure agreement between the municipality and the developer. And it would probably call out that says, okay, the developer's paying these costs, but these costs will be eligible, and it'll specify whether it'll get paid out of the bond proceeds or out of increment directly.
So my concern with that is my impression with TIF currently is that the municipalities that usually do this with the larger ones with staff, they have that oversight. And so I just want to hear from Betsy at some point if they are ready to be able to approve and determine that eligibility with their current labor, how many people they have on staff. So, thank you, David.
Thanks.
Well, and I share that concern, but I think it's the reason to have this language. And I wanted to ask David, I mean, my only close-up experience with TIF was working for the city of Burlington. And of course, I wasn't involved in any of the details, but I do recall at the time that Burlington was big enough to negotiate, and the project was big enough to negotiate in advance that the developer pay, a very high impact fee, pay for the attorneys, pay for all the charrettes and the design process, and could manage that money kind of, even though Burlington did fall under some challenges with its audit around TIF. But what we don't want in the law are any kind of gotcha moments especially for our smaller municipalities who are going to be relying on developers to bring in the initial funding.
Right, but we also don't want this expanded so much that developers are able and sponsors are able to take costs that may or may not be
Well,
appropriate.
but this is a transparency measure about what is or is not appropriate.
Correct. And, right, and you're,
I do understand the concern, senators, and I don't think it's going to be as difficult to monitor as you fear it might be, because the costs, I think the developer is going to have to be able to show, invoices and receipts and so forth that shows what these costs were spent on, so that, if a developer says, I've got an engineering fee for, designing my, site, that's not an eligible cost because it's not involved with setting up the chip. But if they show the legal fees for the attorney who, wrote the infrastructure agreement, that is an eligible cost. So
Right.
I think, it under current circumstances, whether it's with TIF or in the chip as it's written, the costs need to be documented and be able to be later audited by, Tanya or anybody else from the state auditor's office. And so I just think it's a matter of good record keeping, and I don't think it's harder for that record keeping to any harder for it to be done, whether it's paid for by the municipality or paid for by the developer. In either case, the municipality has to have copies of those records.
right, well, it just expands what may be possible as part of the chip increment. I mean, it kind of expands
A difference.
yeah.
I definitely want to hear your thoughts on the next point. This one, I do have concerns. These are hitting public dollars, and I just want to make sure there is a public oversight of the eligibility of these costs. And that's my big concern with smaller based TIFs, is they don't have the staff that municipalities have. And I want to hear from Betsy that they'll be able to provide that oversight for these public dollars. But the next one is where I think there's a lot of interest and a lot of support for that. I'd love to hear your thoughts on it. I didn't mean to segue, Madam Chair. But I'm sure it's fine.
Let's keep going. Happy to keep going.
Well, can I say something before we go on? The intent when we wrote CHIP in this committee last year was that smaller communities would be eligible. The biggest barrier they've had to doing a TIF is that they don't have any of the upfront money to do any of this.
Yeah.
The whole point was that they could we designed it so they could partner with a developer at the start for a site specific project. And it only adds more transparency and less possibility of money going into the wrong places to be transferred to the municipality, to be transferred into the considered costs for the increment. If we're very clear about the developer being a direct partner up front in making this project happen. That was literally the whole point of
That's
site specific
right.
tax
And
increment.
this is why we have asked not to open up CHIP for a year, so that we can see how it works, to see if that is indeed a problem with municipalities. And if it's not, and we have actually, to answer your first concern, David, I understand there are a number of projects in the pipeline, that one is almost ready to go. The Virgins project is almost ready to go. And I think that this is the reason we had asked and had agreement to wait for a year before we open this up. And I'm happy to look at these next session, but this is a good example of why one would want to wait. See if municipalities are facing exactly that challenge, and if it would make sense to open up related costs.
Well, we do have to pay it, even if we wait till next year on this change. This is one that we might look in retrospect. The whole problem is rural Vermont gets left out of first come.
It's not getting left out here. They are applying all of Vermont. I remind us all is rural, and rural Vermont is not being left out. There are a lot of smaller communities, and Betsy can attest to this, that some of the applications are from smaller communities. So I think if this piece in particular is, if it continues to, if it poses a problem, and we will have a whole year of applications and municipalities engaging with Betsy to see if that is in fact.
So happy to move on to section 2 because it's unworkable and unenforceable and would need to be changed for anyone.
I don't. I don't think that anything is unenforceable at the moment.
And on the last one, I just want to hear from them, see what their thoughts are. That's all I'm saying.
We will. You're going to hear from them in a minute. Okay, Dave.
Okay, thank you. So this next one is that under the current statute, it says that any housing unit within the housing development is to be offered exclusively as a primary residence until everything's paid off. And what we have learned already is that lenders are balking big time at this, the private, banks and so forth, because they're concerned about over time the impact, the potential that this is unenforceable because it's so challenging to monitor and control what happens in subsequent turnovers of units, whether they're rental units or whether they're for sale units. And you take an example where a homeowner buys initially a house where the infrastructure has been paid for in part or whole by the CHIP program, and they use it as their primary residence, but then 5 years later they retire and buy a home someplace else, but keep this one as their summertime residence. It's no longer their primary residence. And that's just one of a multitude of different circumstances. Somebody who gets imagine somebody who is a college professor and then for a year goes on sabbatical and rents their home for a year. It's no longer their primary residence, as they're someplace else. There are any number of scenarios where it could be challenging for this, and the lenders are deeply concerned that it would, if it puts that project in violation of its CHIP requirements, that their security position is then harmed, and they don't want to get into lending in the first place when they're at risk for that. So the proposed language here simply says that, and I do want to change one language. As currently written, it says offered by a sponsor. It should say offered by a developer, because if you look at the language and this is my mistake, it's the way we originally forwarded it to but the sponsor is the entity that borrows the money. That could be the municipality, but it could be a third party under the statute. And they aren't necessarily the same ones who would actually be offering the unit. It's the developer offers the unit. So there is, in the draft you have in front of you, an error. And instead of saying offered by a sponsor, just say offered by a developer. The point here is that it would say, what the indication here is that the developer needs to make sure that it'll be used as a primary residence, but it doesn't control what happens subsequently moving down. And this is trying to address the lending community's concern about their security position.
I'd really like us to pause here, because this is the absolute intersection of housing policy and tax policy. And we wrote into the CHIP bill, and people can see it, that the condition, and I tried to say this so we wouldn't keep changing the definition of a non-primary residence on people, which there is an attempt to change in H955, and I really want to work with finance on that piece. It's entirely unworkable. Is that in this case, if tax sees a 20-unit project that was paid for with CHIP, and in 10 years, they start to see that of the 20 units, 10 of them don't submit a landlord certificate or a homestead declaration, then what do they do? Right? Do they then, this is why we have to fix this in H955. Unless we are looking in people's windows or making them submit a landlord-tenant agreement or making them prove 6 months of rental somewhere, which I don't know who's going to do and how, and that's not a number of years. That's a ridiculous challenge. But when we are talking about what they would do in 10 years, who is then paying that money back if they say this is no longer enough a percentage of primary residences, or people didn't file their tax forms that would otherwise demonstrate this? It is going to be a problem for all of us, and possibly complicated encumbrance if we leave this way, especially when Ways and Means has also put a proposal in to change the definition of what a non-primary residence is after the fact.
A primary resident, yeah, it's tough.
So that's a bigger conversation, which I completely agree we need to have, and I do think that the language somewhat addresses those concerns, because I've been going back and forth with Kirby, but if I could recenter it back to this tip piece, I agree to intersect completely and maybe bring John Gray into this. I'd just like to know, can you give me an idea of how much elsewhere in the CHIP language does it give guidance to Betsy that these dollars and then in their evaluation and approval of these projects that they are targeting for what will likely be primary residences and not ski chalets up on mountains, as an example was often used? So where else is there guidance that Betsy in their good judgment will be directing these dollars to places that are much more likely based on development patterns to be primary residences? I agree, unenforceable. You don't want to look in people's windows. And so I'm just curious at the point of sale, how much guidance already is there for us?
We already administer a primary residence verification with the homestead declaration. I mean, we have for hundreds of thousands of Vermonters
But the issue
fill
is
this out, and it has not been
Well,
something that tax.
and
after the first-
Actually, the bill I wrote that you all just edited in H 933, which we all just reaffirmed that definition, is the definition we should continue to use for non-primary residences. It's the exact, it's the only definition we've all ever agreed to. And it essentially says that at the time of sale, so everyone's gonna have to pay a property transfer tax, you have to attest as to whether or not you will use it as your primary residence. So within the same offering that's being made, you simply will not be able to sell it to somebody who, while doing their, final agreement, says that they will not be using it as a primary residence.
Thomas asked a question. So, John, would you be kind of the answer?
Sure, I'll try to help. So John Gray, Office of Legislative Counsel. I think the first direct answer is something that Senator Ron Still has already spoken to, which is that the piece of this language that speaks to the housing infrastructure agreement sets out the condition to satisfy this, providing that landlord certificate or homestead declaration on a by-use basis. That is, you satisfy the condition by doing that. There's kind of a broader answer to your question, which is speaking to what does BEPC do sort of throughout the process that relate to our primary residence determination. It's a little bit looser, but one of the things throughout the program is a check on meeting the statutory purpose of the subchapter, which is to encourage the development of primary residences for low and moderate income Vermonters. That would be included in the plan that you first submit as a municipality to have your project approved. There is some purpose check as well as part of the approval of the application. So even prior to offering any units, there's a check on the plan prior to approval to say that this is creating primary residences.
So the problem, Madam Chair, to the point you offered, and that I understand, Mr. White, that we're trying to fix here is after the first point of sale, the developer develops it, sells it to somebody, 2 years, 3 years later, the tip is still being paid off. But if that person resells it to somebody else,
They could also own it and not treat it as their primary
Right.
residence.
It is very simple.
Yeah.
It had to be in CHIP. It had to be a primary residence until the increment is paid back, until the debt is paid back. That could be 15 years, 20 years. After that, it is far less restrictive. CHIP, primary residence, let me just finish, is far less restrictive than, for example, if you bought a house with the Champlain Housing Trust. Those are permanently required to not be sold to a second homeowner. So the CHIP is only through the debt being repaid. So already CHIP is far more flexible in that regard, but it does require that it be a primary residence. Public taxpayer dollars support primary residences. That's the problem we're trying to solve in Vermont, is people's primary residence, not second homes. Second homes are luxury. I have to remind everybody, second homes are luxury. We are not using public taxpayer dollars to support a luxury.
The unenforceability.
Enforceability of that is preventing uptake of
It has not been a
That's what
problem.
I'm hearing.
And I will say,
Okay.
this goes back
been a problem.
to the change proposed in the definition of a primary residence or a
But
long-term
that's not the
rental.
bill in front. We are.
Well, I will be working on that.
Yes, but I'm happy you're working on that. but that's not in this, these
The
are
affordable housing, comparison is a red herring because they have on-site managers and they truly do have the power and authority through their covenant to look at people's windows. If we started trying to say,
but I don't
you
want to
know,
look at anybody's windows.
there
I want people to file their homestead declarations as hundreds of thousands of Vermonters do. And I
So-
would like us to honor that.
tax should be here. Tax should be here because the question then is, and I think to me, this could be rewritten as language that essentially says, we required that 40% of the project be housing and the other 60% could be other things. We would then be in housing policy promoting a Dollar General over a housing unit that could change from primary to non-primary.
And this is a great conversation for next year. This, once we have a unified and aligned definition of primary residence, great, have this conversation next year.
I'm not gonna accept that because this is affecting financing and affecting
It is,
anybody's ability to say they would participate in something where 10 years later, they could be asked to pay back some debt.
this has so far not proven to be a financing challenge. And we will hear from Betsy in a moment. David, I'd love to get us back on track because we have a limited amount of time. So I'd love to have you finish your amendments and then we're going to hear from others about the amendments.
So, if I may, on this one point, say that I think it is a current problem. That's why we've raised it. We've had multiple lenders, some of whom are very active in the housing world, say to us, this is a problem. It's a barrier to us even investing in projects and lending funds. So I think it's a very current problem. And out of all the things on this list, may be the most important to address sooner than later, because I think it's materially slowing down the potential development of housing, which is the purpose here, is to encourage that. But having said that, let me move on. So the final thing that I want to talk about here is that as currently written, the statute allows for requires the developer to pay the taxes to the community. And then the developer, if the developer has borrowed the money or there's a third party borrower who has borrowed the money to pay for the infrastructure, to get a rebate of those taxes to pay the debt service on the cost of the infrastructure that is being paid for by CHIP. And what that has done is we have had multiple conversations with developers who say this is a problem. It's a cash flow problem because they have to then pay it and wait for that rebate to come back to them. So in the meantime, they've got to be also paying the debt service. So it's kind of a double burden on them. So one of the things we have requested here is to have language that basically would allow, instead of it being a rebate, to be the same dollar amount as a tax credit, so that the developer doesn't have to pay the taxes up front. And this would be spelled out in the housing infrastructure agreement, which mechanism would be used, whether it's a rebate or whether it is a credit. But in either event, it's the same dollar amount that would be eligible here. It would be the cost of the debt service for what has been borrowed to pay for the infrastructure.
Thank you. Any questions for David on that? David, I hope you'll stay with us on during the discussions that we're going to have. Nate, you were up. Welcome. It's good to have you.
Hello.
Would you like to? I'd sort of like to have Betsy next.
I'm totally fine. You guys are way in the weeds. My statements are far more overarching.
Okay. Do you want to then just make overarching and then we'll jump into the weeds with Betsy? I mean, what would you like?
Go ahead.
Okay, great. Wendy and Abby, thank you very much for joining us.
Thank you.
So if you introduce yourselves in your various capacities that you have.
Right, all of
them.
Thank you. Representative Abby Duke from Burlington, and I'm on the FC board as well with the House of Commerce. Wendy Harrison, previously of this committee, senator from, Wyndham on the Betsy board, and both of us were on the, Betsy subcommittee to do the, specific guidelines. So I'm just gonna kind of briefly give you an overview of the process over the past year and sort of how it intersects with some of these issues. So we all know this legislation was passed last year. We were, there were 6 of us maybe on the guideline subcommittee. We met weekly for 3 months to develop the guidelines. It was a very transparent process. Every meeting was public. Every meeting we got robust engagement, we got comments. All of these issues were brought up. I would say all of these issues were brought up during the legislative process a year ago and discussed during the guideline subcommittee process, discussed. And then the Betsy board overall met twice to go over and discuss the guidelines. And approved the guidelines. The subcommittee approved the guidelines unanimously. The full Betsy board approved the guidelines unanimously. 3 months after the guidelines were approved, the Betsy staff launched the program, which honestly is very impressive. It was a staff of 2, now it's a staff of 3. They launched it on January 30th to the public, and have gotten 10, I think, pre-application, like official interest forms. There are a couple of applications that are very close to being submitted, including one from Virgins. I would say the whole process, there's really 3 prongs to it. One was following legislative intent. One was following the actual statute language, like what is the language required, and making it as flexible as we possibly could. Okay, so what's next? So next, it's launched.
So, sorry, in your guideline work,
Yeah.
did you review these amendments? Because we had reviewed them, as you know, in the legislature and said no
Yes.
to these amendments. So did you review these amendment proposals?
We reviewed all of them, and all of them, we made them as flexible as we could within the constraints of both legislative intent and statute language.
I don't think anyone said no to these.
Yes, they did. I mean,
Well, they weren't amendments, they were part of the negotiation
Oh, I
process.
thought those,
We talked about those topics.
I thought you
Yeah,
meant like in the conversation or in.
No, no, I'm talking about in your guideline work.
Talked about these
Did you
items.
consider-
Oh, okay.
Yeah,
In your guideline work, did you consider the proposed amendments?
yes, all of these were proposed. And each of them, and I can go through each of them in a second, one by one. But I just want to kind of level set to where we are now. So, there's been extensive engagement statewide, right? And that has been Betsy's focus, is educating municipalities. It's really a municipal tool for municipalities, educating them about TIF, about how they can engage. And via Vermont League of Cities and Towns, which got a significant grant, provide technical assistance with communities. And so they are working directly with communities to develop agreements and work through it. So ultimately, Betsy's position is there has been and I'm back up too. There's another piece too, which is Betsy has identified a really great model that we're building some of the tools off of, which is TIF in Minnesota. Minnesota has a very active, decades-old TIF program. There are about 1,700 TIFs in the state. It's broader. There's like 5 different categories of TIF that you can do. One of them is focused on housing. Of those 1,700, half or maybe a little bit more than half are in the metro area. The rest are all across the state, including way up on the Canadian border. I mean, very rural. There's TIFs in very rural districts. And there's 2 different financing tools that are used within TIF. One is like standard municipal bond. The other one is they call the pay-go model. It's basically a model in which the developer takes out the loan and the municipality reimburses increment, basically gives them increment over time. And 70% of those TIFs in Minnesota use that pay-go model. So that is something that Betsy has been looking very strongly and has strong partners in Minnesota that are helping them develop the tools, the banknotes, things like that, about that's a new tool for the state. That's a brand new tool for the state. So those are the 2 ways that we see CHIP being implemented as the financing tool, municipal bond or this pay-go model. So we see these issues that have been brought up as stuff that, Pepsi wants to utilize the tools they have, which are the guidelines, which are things like the banknotes, the agreements with municipalities, with developers, to address these issues. And if statutory languages changes is needed, to do that next year. Because there is so much work has been done to line things up for now. Like I'll address jump in if you want to. Like addressing, for example, the related costs. I mean, kind of to your point, like we don't want to get ahead of the agreements with municipalities. Let's see if there's really that rub and concern, and whether or not statute and whether, but we think that the guidelines are flexible enough to be able to address the issue.
Can we pull the guidelines up?
Yes,
Yeah,
Kara's
we can do
got it. John, we can either do that. Kara's going to pick them up.
She's printing.
Oh, okay.
Not to jump around, but my biggest concern is what I think was highlighted in that last testimony is about the unenforceability of after the first point of sale, and that might
The
be
primary
increasing
residence.
uptake by lenders. What are your thoughts on that topic?
So, lenders, there is some concern from lenders about, right, the lenders tend to be conservative, right? They want to understand what are the long-term risks. So the concern is about not necessarily enforceability. The concern is about like what happens if a project is out of compliance, right? Like,
What?
right, is Pepsi going to come back and say you need to pay back the loan tomorrow? We think, at least for the remainder of 2026, let's see if we can't address those issues in the banknotes, in the agreements, because that is, that's kind of where we stand, is that there is concern from the lender community about what are the ramifications if a project gets out of compliance. Because I do think this is a bigger issue about like making sure that the definitions are lined up in terms of landlord certificate and homestead declaration. But I think that is a somewhat different. Really, the nut of this issue is providing what's the right word, like comfort for banks that their investment isn't at risk based on the potential of something being out of compliance 5 years, 10 years down the road. So let's not jump immediately right now to changing statute language. Instead, let's take a look at, maybe there is an adjustment in the Pepsi guidelines that can focus on like what is about enforceability, which the board can do. And the other piece is right now, Pepsi is still developing those banknotes using Minnesota as a model, and working with the lending community to set that up in the banknotes to increase comfort level with the banks.
I take from your answer that the conversation is still fluid and evolving.
It's fluid and evolving, and so much has been built to this point that if we start making changes right now, as applications are coming in, it creates honestly uncertainty and a challenge to make those adjustments.
Lenders don't like uncertainty.
Exactly.
That's what it is.
And this is not, there's one very large project that I think in particular is some of these concerns have been raised about, and I get that, and we want, but I don't think we should be making changes right now in reaction to that project. I think we should acknowledge these issues, do what we can within the guidelines, the tools we have as we look towards next year.
So two things. So I didn't know if, I don't want to ask too much about the 10 projects that have a pre-application in it. We're looking at the guidance. But let's just say with this large housing project, because I talked to Jessica about this month after month, is the attitude was like, we will work it out. My concern is for some of the largest housing projects of the century in Vermont, that we not lose a construction season. And so are you all saying that if this particular issue comes up, you will work in the guidance or in the bank note to make sure that none of these projects lose financing or feel constrained?
I mean, I think we'll certainly try, but I think we also need to stay within the purpose of the legislation, which is for primary residence.
So that's where my second question
Yeah.
is. I mean, what you could be doing is proving my point to go into finance and say, we can't keep changing the definition of what a long-term rental and a primary residence is, because this affects all
Yeah.
of other housing policy. So if you're doing that with me, thank you. Let's take what is proposed in H 955 and what your guidance is and what we wrote into the bill, which is the landlord certificate and the homestead declaration. If a landlord certificate, because all landlord tenant law kicks in at 30 days.
Yep.
Every long-term rental statute in municipalities right now, ordinance is written in at 30 days. Everything, all your rights kick in at 30 days. That is a known number in the landlord tenant law space. If someone files their landlord certificate at 30 days or has their homestead declaration, then tax would generally be satisfied that there's not too many units that are being used as a non-primary residence or not a long-term rental. Let's just say, worst case scenario, H 955 passed as it was written. The municipality is then going to be asked to deem a property a primary residence or not, a long-term rental or not, at 6 months, or have a bona fide landlord-tenant relationship, which I'm working on the language for that. But they would then be deeming a property a second home for that year's tax purposes or property categorization. And how would you treat that potential difference?
I mean, I think we have to address that. I can't tell you right now. It seems to me the issue is focusing on that definition, like you said, focusing on that definition. But I just don't think making a statute change right now when that isn't even, that is a
That hasn't yet
proposal.
been
You know what I mean? I just don't like 100% agree. Like all these laws need to line up, definitions need to line up, but we can't do that. Like I think making this change in anticipation of maybe another definition is changing another law is also not being careful and prudent.
I guess the challenge is this has come up with TIF. I mean, any of us who've been around and on Ways and Means and on finance for a long time, the new people decide we want to change TIF, and then communities, especially smaller ones, are left struggling with how do we get to the legislature to say this would really impact us if you made these changes. I think we'd at least have to grandfather every single proposal from any kind of subsequent changes in the laws that would impact, because that's essentially what we did with TIF over the years. It got very complicated because legislators don't listen to, you can't keep changing the definition.
So, I think that you will explore that when we align things, when definitions are changed. That is certainly why another reason for us to wait until next year before we readdress and open up the CHIP for further amendment. Anything further before we move to Tanya? Because
well, let me just
Go ahead.
I completely agree that this that these changes are should not be made at this time. Our committee spent hours and hours and hours, and it was very transparent. All of our meetings were live streamed. We had lots of testimony from developers. CHIP is intended to benefit small towns primarily, who are not able to do TIFs. The more complicated we make it, is not going to help those small towns. We do have applications in the queue. So this is not the time to change the rules. This would be a terrible time to change the rules. Next year, we'll have some experience, and there will definitely be other items that come up. And so those could be in conflict with what we're talking about now. It just does not make sense. Developers, and especially banks, but also developers, care about predictability. I mean, these conversations are probably even causing some angst in the development community, because if the intention is that every year we're going to change the rules, that's not helpful to really any of these folks. So this is a brand new project or a brand new program. We need to let it go through. It's been very thoughtfully. I think
It's not just development, things for everybody, right?
Yeah.
And everyone's coming to
I want to add one thing.
Abby, add one thing and then Tanya.
Okay, very quickly. I think it's really important to remember that we set this legislation up not to make rules, but guidelines, right? So in order, we can adapt guidelines much faster and more easily than you can update rules.
David
So-
sits on rules, so he's very.
Oh, gosh, yeah, that's, I have sympathy. So,
And gratitude. Sympathy
and gratitude, thank you, and gratitude. So important to realize that within the constraints of the legislative intent and the statutory language, we can adjust the guidelines to meet needs that we see. So including guidelines surrounding how do we deal with the consequences, I guess, of what happens if there is a project that is so-called out of compliance with second laws.
So I do just want to make clear that veggie, TIF, et cetera,
Yeah,
ultimately TAF is the only one that has the information to know who's out of compliance. So they will work with, Jessica or whomever's in that role.
understood.
But it is
Yeah.
hard not to have tax here, because this, no one gets to decide if someone's out of compliance or not at that tax.
I hear you. And I think my point is, I don't think the statutory language of CHIP is where to address that.
Thank you. Thank you both. If you're able to stay for the conversation, great to have you weigh in at different points. We're now going to turn to Tanya Morehouse.
Can I ask another question?
Yeah.
Are you able to say which projects are?
I couldn't tell you right off the top of my head. I know Virgin's is very close to
Yeah, for Jen.
submitting an actual out.
Okay, and you feel like you have a good mix of smaller towns? I mean, Virgin's has a mayor.
Yeah, that's true. Smallest city in the country. Yes, there are smaller towns. There are smaller towns, Berlin, Highgate, some others that are,
Right.
not that maybe the teeny is, they're like 200 person towns, but small towns.
Tanya, welcome.
Morning.
Good morning.
Nice
Thank you
to
for
be
being,
here.
thank you for being here for this conversation. Much appreciated.
Sure. Happy to be here. All right, I'm just gonna pull up my presentation and
If you'd just be kind enough to introduce yourself, and I think you have a copy of your presentation.
sure, let me, I need to share my screen. So I just sent a request for that. Tanya Morehouse, Chief Auditor with the Vermont State Auditor's Office. We provided some testimony, I think, while the CHIP program was being developed last session, and we also provided comments to Betsy as the guideline development process was ongoing. So we've been looking at this program and thinking about it kind of since inception. So let me just make sure I can share my screen here. Can you see my presentation? Hopefully you can.
We can,
All right, great.
and we
Okay.
can see you in the corner.
All right, even better. All right, so it's very interesting to hear everyone's perspective on this. I'm going to focus on the 4 primary changes, which, the public good criteria, the related costs issue, the primary residence change, and then on the expansion on the use of tax increments. Our overall perspective is that these changes either remove an existing constraint or provide additional flexibility to the developers. But along with that comes increased chances that the projects won't serve the legislative intent and may not serve or provide a public benefit, and could end up allowing taxpayer support for second homes and short-term rentals, which is some of the concerns I've heard expressed. And essentially, in all respects, these changes to us lower guardrails that are currently in place. So you had lots of discussion about this. I'm not going to belabor this point, but essentially it removes the public good requirement that is currently in place for infrastructure improvement projects. What you're left with is the remaining guardrail is essentially the but-for test, which is embedded in that purpose statement. So I'm just going to flip back, sorry. So this is currently a 2-prong test, public good and the purpose stated in section 1907. So you're left with just the projects having to meet the purpose stated here. And part of this is the reliance on the but-for, which is, essentially the project won't occur unless the infrastructure improvement is funded by CHIP. Now, based on our experience with economic development programs, it's fairly difficult to validate whether a public subsidy is necessary or critical.
I will say,
thing,
we looked to Minnesota for how they administer their or test.
Was that a question for me?
No, just that we've always looked to Minnesota for good tax policy, and they have an enforceable but-for test.
Okay, well, our perspective is it's very difficult, if not impossible, to audit that but-for, and it's also difficult to verify it. So the other thing that I wanted to point out is that removing the public good criteria as part of that test of whether an infrastructure improvement can be funded with CHIP essentially nullifies what is in the existing guidelines for the CHIP program on what is meant by a public good. So VEPC has taken the time and laid it out in their guidelines pretty clearly, I think, what it means to be a public good. So just has to meet one of these thresholds: publicly owned, publicly accessible. That's probably familiar to everybody because that's part of the existing TIF program. Privately owned, publicly accessible, or if it's privately owned and restricted, to private use, well, then it has to demonstrate community benefit. This test would be gone if you remove the public good criteria from statute.
Ask a question about CHIP.
Yes, Tom.
So thank you for this, Tanya. I think it was raised, and just as an example in that previous language, if a large high-density housing complex were to come in and they needed to build a parking garage, which is often a necessity in more urban areas, and parking garages are incredibly expensive, would you see that as falling squarely in item number 3 if it was still privately owned and privately accessible to just the residents of the place, or would that be excluded from that definition in your mind?
Well, I think it would fall in that third bucket, but what would be required is they would have to demonstrate that there's some kind of community benefit from that privately owned and restricted access improvement.
That would be demonstrated to VEPC, they would evaluate it.
Yeah.
Yeah.
Okay. All right.
So
I
can I add something to that?
Yeah.
So we talked a lot about privately owned and publicly accessible, because that's really important. And that's often what a garage is, a parking garage. And
Just for the residents.
it can be just for the residents, or you would have a section of it be for the residents and a section be public. And that works well in developments, but that was actually a stretch to say privately owned and publicly accessible. The privately owned was something that we talked about a lot, and then did get to this.
I mean, we have had debate after debate in Ways and Means about a parking garage and whether or not it should be free for 2 hours, and that makes it publicly accessible. So, we've heard that, like these are all, we're raising concerns by talking about these things. Any halfway decent attorney has thought about all of the things we're talking about and has those concerns. So I just want to stay here for a second because the public good piece, I think the question was, does it serve a public good and fulfill the purpose stated in this section? So did you all talk about that? Like, does it have to meet it? You say or. So I think in your guidance, you've achieved what they're asking us to change here, which is congruency about the public good being one of these three things, not being two of these. That's right. Three things. So I guess I would just say, can it wait till next year because nobody's going to get stuck on this? Probably, but what is being requested is that we fix the statutory language to match what you all did in your guidance, which is say all of these are an or, not two of the three. And so, Tanya, what would you, when you read will serve a public good and fulfill the purpose stated in section 1907, do you read that as two of these things have to be satisfied, and would you audit that way?
No, so the current language, let me just flip back, ignoring the underline and the strikeout, it says it has to serve a public good and the purpose stated in 1907. So we would go to VEPC's guidelines and we would say, oh, how is the public good defined? It has to meet one of these points because there's ors here, not ands. It's an or. But the and is that it has to meet one of these and the purpose in 1907. The change is
So can you go back to
nullifying these.
1907?
Yeah, the change nullifies this. It would just, if you eliminate the public good criteria, you don't need these guidelines. So you would just be left with this, which is, it just needs to show that it meets the purpose, which is, to encourage primary residence for low moderate income that would not be created but for the infrastructure improvements being funded by the program. So what I'm trying to highlight here is, I think this is somewhat on its own, a weak criteria because the but for is very difficult to validate.
So Tanya, if you'd be kind just to finish, we have Ted
Sure.
Barnett is up. So thank you.
So just to kind of end on this particular item, the implication of the risk here is that market rate housing projects, which have no requirement to set aside units for low income or moderate income households, could end up receiving public funds but provide no public good and only be subject to a but-for test that we believe is difficult to validate. So essentially, you could open the floodgate to allow any type of developer infrastructure costs to be paid for with public funds. And our suggestion is you just defer consideration until VEPC has more experience to inform the discussion. The next item related, do you want me to keep going through or do you want to just go to Ted?
Oh, this is good, and then we're gonna have Ted.
Okay, so with regard to related costs, this would of course expand the universe of related costs in statute to those incurred and paid by a sponsored developer. Right now, the VEPC CHIP guidelines include related costs of sponsors and developers as an eligible related cost. So I guess, having it in the statute, kind of closes it down, makes it clear in statute, but it already is in the CHIP guidelines. I think what the risk is that remains is that it's not clear that the developer or sponsor related costs will be subject to VEPC authorization and municipal validation. And I think that's what Senator Chittenden has expressed some concern about, because he's asked questions a couple times around how would those costs be monitored, how would they be validated. So currently the CHIP guidelines are really explicit about expectations for municipalities of implementing procedures to validate infrastructure improvement costs, but do not address developer / sponsor related costs. So that could be made more clear. I think David White had mentioned in his testimony that it would be spelled out in the infrastructure agreement between the municipality and the developer. That is another good thing, another way to kind of clarify and make sure that the developers understand. They have to spell it all out, have agreement, and then provide evidence to validate that their costs are eligible. I will tell you that this is an area in our experience with TIF districts where we see it as a higher risk. And that risk is both interpretation and administrative risk. So kind of going way back, 2011, 2012, Winooski charged their municipal operating costs to the TIF district. This was before the statute was kind of locked down and made more explicit about what was allowed for related costs. The TIF rules also do a good job of addressing it now, and that was pre-TIF rules. More recently, the Burlington Waterfront TIF, they use tax increment to pay for internal staff attorney costs. And that, I think, is not an interpretation risk, but it highlights the kind of municipal administrative risk. These are complicated things for municipalities to manage. And in Burlington, the people that were approving the costs and had eyes on, what was being charged to the TIF, I don't think they really understood the related cost rules. And so that's how the staff attorney costs ended up getting charged to the TIF district. In St. Albans, we had some issues around a broker fee that tax increment paid for. It was in connection with a sale to a developer of some property that was owned by the city. And the issue that we had there was, well, is that really a related cost associated with the implementation of a TIF district improvement, or was it a private development cost? And so at any rate, my point is, it's difficult to kind of manage these things. And our suggestion is either, if you're not going to make the change in statute, remove the reference from the VEPC CHIP guidelines to the sponsor and developer related costs being eligible. Or if you're going to make the change, then also request that VEPC modify their guidelines to specify that VEPC needs to authorize the sponsor developer related costs, and municipalities have to obtain appropriate documentation from the sponsors and developers to substantiate those costs. Any questions on that?
No, thank you. This is
Okay. For the primary residence, the effect, of course, is that this has been discussed already, but that essentially the requirement to maintain the units would not apply to any subsequent transactions. And in some instances, that could possibly be immediate upon project completion. The implications or risk it appears inconsistent with the purpose of the program, could significantly shorten or eliminate the period that the units are preserved as primary residences, and increases the risk that public funds are used for projects that don't produce the intended outcomes. I think this is, the crux of the discussions that have been happening. And for this one, our suggestion is just defer consideration until there's more experience that can inform the discussion.
okay. Thank you. I think we have a question here. It's from Geisha.
So, I think a lot of this is about sorry, I'm standing up because I said I'd go support our congresswoman across the street in a minute. But this hinges on, you know, what might get audited in the future, what would be considered acceptable under the language we have passed at this time. And an alternative question that has been posed to me by some lawyers who are following this is, if we required that 40% of the project meet the primary residence housing requirement to be eligible as meeting the purpose, could the other 60% be not only commercial or, you know, some other type of use, but would tax be able to say, okay, some percentage of these have not filed a landlord certificate or a homestead declaration, but 40% did.
I'm sorry, what's your question? Are you asking me if that's a logical way to address this?
Is it logical, or would it pass an audit in your mind if the other 60% was a commercial property or a non-primary residence?
So based on my reading of statute and the current guidelines, I think the requirement is that housing has to be 60% of the floor space or something along those lines. And
Right.
I think that the guidelines specify that that housing has to be primary residence.
Mhm.
I'm not sure it says, I don't think it's as
It's a
explicit in
theoretical.
statute, right? So I think the way to approach this is think about BEPC, can think about whether there can be some adjudication process that allows for some level of flexibility. But I can't tell you whether the 40% of the 60% would pass muster or not. I think that's a decision that BEPC has to make.
I think that's a good question for BEPC, is if you have a housing project that does have a commercial component, which we know is also a PHP, a benefit to our communities, what percentage of the housing would have to be primary residences to satisfy the concern, depending on and I think we tried to get away from square footage, because that kind of lends itself to luxury housing, picking up more of that housing. So anyway, this is, I think, a really good question for, you know, you all. And I mean, I believe our intent was to try and create as many housing units as possible. And so, you know, like, period. So, you know, and not that worry 10 years down the road, do they have a commercial piece, and is this a non-primary residence now, and what percentage of that? So it is a question you all will probably have to answer year after year.
Or
Well, this is a judgment issue. It's a judgment issue on a case-by-case basis, and that's something that BEPC would have to make.
Right.
Now, I've seen some examples of people say, question, Professor, for example, who goes on a sabbatical for a year. During that year, that property is leased. Does that?
That's a primary
Use-
resident.
that's
No,
still
that's still
primary.
primary resident. So
But
that's
really-
the thing.
As evidenced by the landlord certificate only, which
It is.
the question is, we can't change the rules on people.
Yeah,
From
but what
the
we can
definition we
do
apply
is
it.
the board, as the BEPC board can exercise some judgment.
That's right.
In terms of the measurement that from the auditor's perspective as to whether they are or not complying, they have to look at that judgment and the basis for it and what's in the statute.
So they can only make that judgment if tax has a flag for what would be out of compliance.
that tax has the homestead declaration.
Tax
and the
is really
landlord
great.
certificate. Tanya, would you be kind enough to finish?
Okay, so turning to the last proposed change. So this would add to the use of tax increment. And so essentially it would be reimbursing taxes that have already been paid or as a credit against taxes due. So just to jump right to kind of implications or risks, this change, because of the way that it was written, eliminates the verification guardrail that currently exists. So what I mean by that is in the existing law, sponsors have to provide an invoice as evidence to substantiate that debt payment is due, and then they also have to confirm once they've applied that tax increment to pay the debt. So this ensures that tax increment goes to permissible use. Underlying this also is in the guidelines, municipalities, I think as I mentioned earlier, have specific requirements to set up procedures so that they're validating the costs of the infrastructure improvement project that the developers are doing. So it's not just what's in the law, but it's also what has been set up in the guidelines in terms of the procedures and the oversight that the municipalities need to have. The proposed change doesn't address the evidence required to be provided that would then prompt payment. Also, this could be complicated to operationalize in the context of the municipal and state property tax systems. And the reason that I say that is the mechanisms that are in place right now for facilitating the management and kind of the flow of funds for tax increment, the ones that are in place for TIF, I think would probably be replicated for the CHIP program. The TIF program does not have this type of wrinkle in terms of a reimbursement of taxes or kind of a reduction of future taxes due. And I'm not sure how this could actually be incorporated in the current processes.
Right.
And my concern is that it would lead to some kind of off book or on the side accounting and tracking that would be difficult for a municipality to manage. Also, when you read the language, it kind of has the appearance of either being a tax abatement or an exemption, and that could impact local taxpayers' property tax obligations. So generally, when tax abatement or tax exemptions are granted by a municipality, the municipality still owes the state education funds. They don't have the authority to just kind of wipe those out. What happens in that case is that the municipalities add a local agreement rate to their municipal tax rate such that it's high enough to raise those taxes that they've excused a property owner from. So the municipal tax rate is higher for all taxpayers. And I'm just not sure how this language would be interpreted and whether this kind of item would kick in. So the suggestion here is to consult with the Department of Taxes Director of Property Valuation and Review about these last two items, whether they could operationalize the way these funds would flow in their current system, and also if there would be any impact on local taxpayers. So that's it.
Tanya, thank you. That really, you have done a huge amount of work reviewing this, and we're very grateful, very helpful. This is one of the challenges with having major proposals at the last minute. I mean, just this alone, if we were going to do a proper job on this, and we weren't already committed to letting CHIP roll out for a year without interfering with it, I mean, this alone requires Art to really dig in with tax and with the, as you say, the Director of Property Valuation and Review. So I really, I'm so grateful to you for sort of reviewing these and helping us appreciate some of the implications that these proposals present us with. And it helps us understand some of the implications of these proposals. Thank you. We'd love to have you stick around for Ted Barnett's, the JFO's testimony. If you're able, that would be great. But if not, this is really helpful. Thank you very much. Really, I have to remember that speak to the tube and not to the screen. So thank you so much. Really appreciate it.
You're welcome. I was happy to be here. And I will hang around.
Ted, if you'd be kind enough to join us, that would be great.
Just give it to you.
Thank you, Tanya. And David is still with us, I think, as well.
Okay, I am hopping, Tempernet Joint Fiscal Office, I'm hopping in the Zoom right now.
Yep.
And then I'll go share my screen, so we'll have a 30-second hold music moment while I'm pulling everything up. Wish I could choose my own adventure on the exact hold music that could play while I'm doing it.
Oh, there's a nice idea.
Okay. So here's given kind of the time frame we had to think about this proposal, and given the work we did last session on the CHIP program, we developed a memo that kind of outlines more fiscal implications or considerations around these proposed amendments. As a reminder, JFO was not able to estimate the fiscal impact of CHIP last session when it was enacted in Act 69. There are just too many unknown variables for the broader program to put a specific number on it. Right, it depends on the number and types of projects approved. There's different retention percentages, whether the program or the project meets affordability criteria. Depends on the affordable project and not subject to the but-for test. We don't know how different programs are going to meet that but-for. And then, given all of our uncertainty around the education finance system, we don't know what future tax rates will be. So all of those various pieces made it impossible for us to put a number on the fiscal impact of CHIP. So given that, what I decided, all those considerations for this particular piece, we decided to really focus on the increment that is generated, and then so increments that's generated, a percentage of that increment, 75% for market rate, 85% for affordable housing projects, right, that can be used to finance the CHIP program. And broadly speaking, by increasing the types of uses for that increment, regardless of how you feel about the but-for test, you will have more increment committed to those uses, which are ed fund dollars that would normally be returned, that could be returned to the education fund through a certain set of processes that are outlined in the statute. So that kind of tees up the conversation. The amount of statute outlines that increment that is retained beyond what is needed for payment of financing and related costs are used to prepay principal and interest on financing to be held in a certain financing account for future financing and payments. And that's generally what happens in current TIF projects, right? They're generating a certain amount of increment. If that increment is more than what they need to pay for debt service in that current year, they place it in a TIF account that can be used for future financing payments. Oftentimes the bonds are structured to run longer than and so they can build up a surplus to make those debt payments out into the future. And then it can be used for pieces of the financing is the third use. And so of the excess that is remaining, it can be returned to the education fund through three processes outlined in the same section of statute. First, in a given year, it can be distributed to the ed fund. We don't see this happening in TIF districts, but it is outlined in statute as a possibility. Two, in the 10th year following the creation of a TIF project, statute requires the CHIP project to issue a financing plan to BEPC, and at which place BEPC evaluates the amount of increment they're generating and sees whether the retention percentage can be lowered, so they're holding on to fewer incremental dollars, returning more money to the municipality and the education fund. So that's the process in statute. So if the project's doing super well, it's designed so that the project is holding on to ed fund dollars unnecessarily for the duration of the retention period. And then at the end of the project, any remaining ed fund dollars after the payment of financing would get returned back to the education fund. So we really tried to focus for this analysis on those incremental dollars, given that in any case, there are a variety of ways in which they can get returned to the education fund. With that in mind, we're going to run through each of the 4 proposed amendments. As a highlight here in bold, right, we are not able to forecast the exact fiscal impact of those amendments, given all of our challenges forecasting the broader impacts of CHIP. But as I've said a number of times, they would expand the uses of tax increment dollars, which would negatively impact the education fund throughout the retention period of CHIP projects.
Comments?
To your point, with that very important statement there, could you also say that it would expand the uptake of CHIP projects, which might ultimately have the benefit of more housing projects, which ultimately could grow the grant list years? See my
I do see your point. So it is really hard to evaluate those additional projects, how they're meeting the but-for test. And so, right, because of the way the but-for test is construction in statute, it's not and there is there's a strong, like the JFO but-for test is whether the development would happen anywhere else in the state, right? Because if it's happening anywhere elsewhere in the state, the 100% of that incremental value is being returned to the education fund. If it's happening in a CHIP project, they're only remitting a certain portion to the education fund. I would also note that the but-for test in statute allows FEPC to approve projects that would happen in a substantially different or less desirable manner. And so it's not a binary either or, that just because the project is financed through CHIP. And finally, the affordable housing projects are not required to meet the but-for at all. So you could theoretically make the same argument that because they're not required to meet the but-for, those projects would have happened anyway, and so they're a full cost of the education fund. So I think, like, given those but-for considerations,
was challenging there.
Yeah,
to expound upon it.
totally understand. So that's why we chose in this memo to really focus on the use of incremental dollars, because it simply, even if you view CHIP as a benefit to the education fund, there would be fewer of those dollars
To send back. What you're saying is there'll be fewer dollars to send back.
Exactly. In any case.
Yeah, although our long-term hope with all TIP and CHIP projects is that more money will be coming to the ed fund, because we'll be generating more housing and more tax revenue and more all of it.
Yes, and at the end of retention periods, right, the grant list would be larger.
And every TIP, we get full rate of the increased value of the grant list.
Yeah, and unfortunately that benefit fully realizes 20 years of future.
Right. Well, some of us, have to have patience with these.
Exactly. Right. So on the first piece, and I will, as I go through each of these points, a lot of these points will be similar to the presentation from Tanya. Yes, we are. I was happy to see many of those points in our presentation.
Yes, that would have been.
So the first one, changing the definition of improvements, so that privately accessible improvements would no longer be required to demonstrate community benefits of that infrastructure. Similarly, so this would likely increase the amount of private infrastructure funded through CHIP. The example referenced before, parking garage, parking lots is kind of the main piece of infrastructure we're seeing implicated here. If this private infrastructure would have been a part of the project anyway, but not eligible to be financed with increment, it would decrease the amount of increment left over after financing, reducing money to flow to the education fund. The second piece is talking about related costs, including plan development, public engagement, consulting fees. Real note that, again, greater use of increment, fewer dollars that can be returned to the education fund. And I wanted to provide within this memo some scope of related costs as a share of the overall project. Related costs they can certainly add up. So I looked at the phase filing from Killington as a part of their plan that they put forward. So for $47 million in debt principal, nearly $900,000 that was financed through bonding was related costs. So by opening this up to developer or sponsor related costs, it could certainly start to represent a sizable piece. If depending on the scope of projects and who's implementing them, it could certainly start to add up. We similarly spent a lot of time thinking about the mechanics of the piece that would allow reimbursements from municipality or payment to sponsors of development to take the form of taxes or credit for taxes due. Given, I think we share the concern that it can appear as though it is a tax abatement type structure. This memo focuses on it simply changing the form of the payment that happens to a development or sponsor. So rather than it going out the door as some sort of cash, it is a credit as taxes due. Best case scenario, that credit as taxes due is, in line with a normal financing plan where the amount of increment is supposed to cover the cost of that financing. It would cover the amount of taxes due. It's kind of a best case scenario. You can imagine a situation in which a municipality has said certainly developer or sponsor will issue a credit of a certain amount. The increment doesn't get realized, but they're still on the hook for those payments.
Yeah, and that's one of the big concerns of tax abatements. If they are, then the city of Burlington is on the hook for making up that difference and sending it to the ed fund.
Exactly. And it's the same risk that applies in any sort of TIF chip project, is that you are relying on a certain amount of increment to come in. But I will note that I also share the concern that it considerably within state auditor reports, there are a number of challenges in implementing tax increment and correctly calculating the increment under the current structure in TIF projects. So by adding an additional wrinkle of credits against taxes due, you're certainly offering the possibility for those calculations to be more complicated and increasing the possibility for mistakes, which already happen in the current TIF program. And then finally, the proposed amendment that's certainly getting the most attention is this idea that the limitation on chip units created through chip being offered as primary residences in the current law for the duration of the debt retention period. This would
It's not being offered. Offered being easy. It's just the maintaining enforceability of it being used as a primary residence throughout the life of the debt.
Which some of us don't think is that challenging to enforce, given that we have this with hundreds of thousands of homes that are primary residents who have to.
Initial offering seems easy. It's just the resale, we don't have much control.
Right.
And that is exactly the concern. We could see this under the current structure of the language. We could see the sponsor offering those units to some sort of private or property management company that then offers those units as they transfer them as secondary residences, et cetera. So that mechanic can happen pretty quickly. And you have no real, right, as you mentioned, right, there's no real control over the duration by which these units created are maintained as primary residences. And the law last year, I think there's quite a bit of debate on this particular subject, right? The decision was to make it.
Already weighed this consideration and made a decision on it.
Yeah. And I do want to flag that, yes, there is a concern that these could be transferred and converted into secondary residences or even short-term rentals far earlier than you would have intended. The second piece is this is the purpose statement clearly identifies that the program is to encourage the development of new primary residences. And the proposed amendment may reduce the number of primary residences, or likely will. And then the other piece I wanted to make, which it's not often I get to talk about the academic literature, but I always enjoy when I get to, is there was research recently conducted by two academics at UVM, Joe Ammett and Chris McElroy. I hope I said both their names correctly. But they looked at housing price increases in Burlington, and their explanation, or what they found in the data, is that these price increases are more of a demand side explanation. So the fact that you have more investor activity in housing in Burlington, the fact that you have people who are able to offer greater down payments for properties in Burlington, that competition for units was a better explanation for the increases in Burlington compared to any sort of supply side constraints. And so by offering, opening up these units to, at second or later transfers, opening them up to a greater competition from potential buyers, that could potentially increase the price of the unit compared to current law within those CHIP developments. And again, the purposes of the program is to encourage the development of residences for households of lower and moderate incomes, so really speaking to the affordability of those units. And so given this research, there is a concern by increasing competition, it could make these units less affordable to Vermont.
Yeah, thank you very much. Thank you for taking the time. We're very grateful to have your eyes and ears on and analyzing the implications of these proposals. We have to vote H775 out tomorrow at the latest. I had hoped I would love to have some committee discussion of this. I appreciate proposals at any point to improve things, but we really, I think Bepsi's interest and our support in January when Jessica Hartladen came in, the House and the Senate and Jessica all agreed for us to look at these in any substantive changes next year. John, are you leaving or are you going to join us? Are you
I'm
leaving?
later.
Okay. Well, next year. And so and given that we have a few more issues with H775 tomorrow to iron out before we vote it out, these proposals of amendment have already taken another hour and 45 minutes of our time, and I so appreciate all the implications and all the analysis and the ideas behind them. But I think coming at this hour, at this day, they're substantial enough. These are not technical changes. These are major changes. They have been rejected 3 times by this legislature, by the BEPC board, and by the BEPC guidelines task force. I would really ask the committee at this point to decide not to include these amendments in H775 at this.
Definitely want to hear from Senator Reese, Senator Brock. I'm leaning that way as well, but I just want to say this was a good use of our time.
Yeah.
If anything, I wish we had had it a couple of weeks ago, so we weren't as feeling under the pressure.
Had we
But
had
CHIP was landmark legislation, so revisiting it, hearing from people on the ground about what they're experiencing is great. But the testimony from Bepsi was quite compelling. I am more inclined to give it the year, but that's where I am. I'd love to.
That's where I am as well.
And I think we can be really proud. We can be really proud of the program.
We're proud of it, and we're proud of all the tip work David's done. I mean, I'm proud of all this work. This
For sure.
which we had work. Actually, so with that, Senator Clerk, I would love to have you I think let's do a poll on this, and I would ask for a motion to not include these amendments in our bill at the moment.
I think our standard rule is we don't make motions in the negative, so you'd want a motion for it and then you vote against it. But I don't even know if that's necessary.
Okay.
You might as well.
We don't pick it up. We don't pick it up.
Okay, so the decision, my sense from the committee, just in a straw poll to include these amendments into the bill. For those who support including them in the bill, please raise your hand. Those who oppose including them in the bill, please raise your hand. Thank you very much, Ted. This was a great use. I hope it was a great use of your time. I certainly, as we go forward, it will certainly inform all your CHIP work. So thank you very much. Bepsi, thank you. Thank you, Abby, for taking that from your committee. Thank you, all of us. David, thank you. Good to have this conversation again. And there we are. Thank you very much.
Thanks while you're doing a
To the floor.